So, saan tayo huling natapos? Oh, yan. Dito tayo natapos sa Mr. C. Sudi. Saan ko naman makikita yun? ₱72. Oh, ito naman pala eh. Mr. C. Sudi. Okay, game. Mr. C. Sudi. Okay, add. Ito na. Okay. Game, guys. Teka, check ko lang pala yung live stream natin kung okay na ba. Ah, nakalimutan ko mag-post. Pala? Ano ba yun? Okay, game na tayo. Online ako sa Facebook and sa YouTube ba? Yan, okay na. G. Okay, Mrs. E filed a complaint for sum of money against Mr. F in the amount of 1 million before the RTC. After due proceedings, the RTC ruled in favor of Mrs. E. And since no appeal was interposed thereto, the ruling became final and executory as evidenced by an entry of judgment dated July 2, 2012. Okay, sige. However, Mrs. E was unable to immediately move for the execution of said judgment because she had work engagement overseas. On June 29, 2017, Mrs. E, DMD, returned to the country and on the same day filed a motion for the issuance of a writ of execution before the RTC. Okay, nagkaroon ng entry of judgment July 2. So, nag-work siya sa abroad. Tapos, noong 2017, which is within the 5-year reglementary period for motion to execute pa yun. Yan. Filed the motion for the issuance of writ of execution. Okay, the RTC granted the motion. Okay. Was the RTC's issuance of the writ of execution procedurally infirm? 2017 siya nag-file ng writ of execution. Tapos, nung July 7, nag-grant yung motion. Okay. Hindi ko din sure. Okay. 5 years. Yun lang naman pala issue, 5 years. Tatama tayo dyan kung yun lang yung huhulaan natin. Sige. Game. Back. Okay. Kalimutan ko yung aking stopwatch. Okay, next. $73 to $84. Mrs. G defaulted in the payment of her loan obligation with Z-Bank. As such, the Z-Bank extrajudicially foreclosed Mrs. G's mortgage property and sold it at auction, where it emerged as the highest bidder. Eventually, a certificate of sale was issued in Z-Bank's favor, and title of the property was later consolidated under the bank's name. Claiming that Z-Bank used fraudulent machinations, increasing the interest and penalty charges on the loan, thereby making it impossible for her to pay, Mrs. G filed before the RTC a complaint for cancellation of consolidation of ownership over a real property with prayer for the issuance of a writ of preliminary injunction against Z-Bank. Immediately thereafter, the RTC issued an ex parte writ of preliminary injunction enjoining Z-Bank from disposing of the foreclosed property or taking possession thereof. Did the RTC, her issuing the writ of preliminary injunction ex parte? Okay, kailangan ko mag-focus dun sa tanong. Napapansin ko sa sarili ko, hindi ako focus sa tanong eh. Naghahanap ako ibang issue. So, focus tayo dun sa tanong. Okay. Error daw ba yung RTC sa issuing ng writ of preliminary injunction ex parte? Okay. So, sasagutin natin yon immediately. Hindi. Mali. My answer, no, yes. The RTC erred in issuing the writ. Under the rules, in order to validly issue a writ of preliminary injunction, there must have been it must have there must be a hearing must be conducted to determine whether the proper grounds for issuing the writ are present. Here, the writ was issued ex parte with no opportunity to determine the propriety of the grounds such motion. Hence, the issuance of the writ was not valid. Hence, the RTC erred in issuing the writ. Yes, the RTC writ of issue, but only after notice and hearing to the adverse party. Ba't ang ikli na ng mga sagot? Napagod na. Ikli na ng sagot. Okay. Mr. H filed a complaint against Mr. I to recover the amount of $500,000 based on their contract services. In his answer, Mr. I admitted that he has yet to pay Mr. H for his services based on their contract, but nevertheless interposed a counterclaim alleging that Mr. H still owed him rental arrearages for the lease of his apartment, also amounting to $800,000. Teka, translate natin sa Tagalog ha. Si H nag-file ng complaint against I para sa $500,000 for their contract of services. Sumagot naman si I, sabi niya, babayaran mo pa ako ng rental na utang mo. Okay, it's a matter of offsetting ba? So it has come to Mr. H's attention that Mr. I did not pay any filing fees when he filed his answer. As such, Mr. H moved to dismiss the counterclaim. In response to Mr. H's motion, Mr. I averred that the non-payment file was purely based on inadvertence and that the said filing fees had already been paid as of date. Okay. So, okay. Question. What is the nature of Mr. I's counterclaim? No, what is the nature daw? Okay. I would say the nature would be letter A. Mr. I's counterclaim is a compulsory, hindi pala, sorry. Ano to? Is a permissive counterclaim. Under the rules, counterclaim is permissive. But actually, ano ba to? The same is not unnecessary. Ang compulsory counterclaim is needed for the full determination of the the claims. The final determination of the claims. Hindi pala. Compulsory pala yun. Hindi yun. Parties yun. A counterclaim is permissive when the same is. Ano ba? Parang wala ako sa vision mo sumagot. Under the rules, a counterclaim is permissive when the same is not rising or intimately related to the case at hand. Action giving rise to the cause of action. Yes, the filing fees are required to perfect a permissive counterclaim. B. Counterclaim be dismissed. Yes, Mr. I's counterclaim, being a permissive one, must be dismissed. Failure to pay the corresponding docket fees under the rules would result to an would make the counterclaim invalid. Here, Mr. I's counterclaim was not paid for at the time it was filed. Teka, pwede naman bayaran yung docket fees eh. Alam ko pwede ihabol yun eh. Sabi niya bayad na daw yun ngayon. Oo nga no. Hindi pala dapat i-dismiss. No, Mr. I's Counterclaim did not be dismissed. Non-payment of docket fees is curable through actual payment of the corresponding docket fees, since he was able to show that receipt payment of the docket fees. The same may be appreciated by the court if it so wishes. Okay, sige. O permissive counterclaim does not arise of or is connected. May pa-intimately connected pa ako, no? The transaction or occurrence considered the subject matter of the parties opposing. Okay, Mr. I's counterclaim for rental. Okay. So the nature of a permissive counterclaim. Jurisdictional, oo. Oh, yan. Oh, so pwede. Tama tayo. Siguro mga 3 to 4 points to. Pwede na. Tumatama tayo, guys. Medyo malapit yung concept, pero malayo na, pero malangi yung malayo pa. So, sige. 7 minutes 42. May 6% lang yun. As a result of an anonymous complaint, Mr. J, a local public official, was held administratively liable for grave misconduct by the Office of the Ombudsman in Administrative Case 1234. As such, was imposed the penalty of dismissal from service. The Ombudsman also found probable cause to indict him for violation of 3019. Mr. J moved for the reconciliation of the Ombudsman just was denied. Unperturbed. Mr. J filed a petition for certiorari under Rule 65 and CA, assailing Ombudsman Joint Edition. Okay. However, CA dismissed the petition outright, holding such petition constitutional improperly to assail the administrative and criminal aspects of the aforementioned. Okay. Okay. No. The CA's dismissal is not correct. Under Rule 47, 43 ba yun? 43? Under the rules. Hindi ko sure. Final decisions of the Ombudsman pala under RA 1319. Proper mode of appeal for cases decided by the Ombudsman is appeal a petition for review in certiorari under Rule 65. Here, for certiorari was filed. Grabe, ano ito ako ba ganun? Share my. Tulog ko muna ito. Ang bigat na mata ko. Hindi pa akong 20 minutes. Here, the petition for certiorari was filed under Rule 65. Hence, the proper mode of appeal was used. Dismissal is improper. Accuracy. Tama pala. Rule 43 nga. Okay. Sige. Teka lang. Sobrang bigat naman ito.